This is Dabbling with Data, a show where we discuss the intricacies of all things data in the contemporary world. We focus on ranging topics that affect the citizens of today, such as intellectual property, research ethics, misinformation, algorithm bias, and more. Sit back and relax as you listen to a panel of undergraduate students at the University of Washington converse about the future of information ethics and policy. Welcome to this week's podcast of Dabbling with Data. My name is Matthew Scholl, and I am your host for today. I'm joined by Brenda Obonio, Daniel Cavazos, and Eric Kim. Today we will be discussing something that will affect us all in the future, which is the Washington Privacy Act, also known as the WPA. So, some background information on the WPA is that following the California Consumer Privacy Act of 2018, Washington followed suit by trying to implement a privacy act for citizens in the state. This act has failed for the past 3 years, with the most recent version being defeated in the Washington House of Representatives, although supported by the Senate. This bill contains a multitude of protections and restrictions in privacy, ranging from consumer rights to business obligation. To my guests today, I propose a question of would you pass the 2021 Washington Privacy Act, and what are the implications of this?
Yeah, so I'm Daniel Cavazos. I'm a third-year student at the University of Washington studying informatics. I think the WPA has a lot of great aspects to it, including the right to access, the right to delete, and the ability to opt in consent for sensitive data. I do think, however, in its current state, it lacks some key features such as how it enforces its rules. Right now, the Attorney General of Washington is the only one who can prosecute regarding the act. However, I believe that it should be available to civil suits as well.
I'm Eric Kim. I'm a second-year student studying informatics, and like Daniel, I also agree that the Washington Privacy Act isn't really up to spec. That I think for example, with the People's Privacy Act, that exists as a better option for the citizens of Washington State in terms of not only offering similar, if not better, protections than the Washington Privacy Act, but allowing people to take action on their own against any company that they have grievances with. So, yeah.
My name is Brenda Obonio, and I'm a senior studying informatics. And for me, it's simple. Yes, I would pass the bill because consumers have the right to know who is collecting their data and how their data is being used, among other things. Most importantly, I feel like having this law, as much as it's flawed in some ways, is a good start at what needs to be regulated.
Okay, my name is Matthew Scholl. I'm a fourth-year student studying industrial engineering. So I also agree with Brenda. Likewise, there's a lot of things that us as citizens of Washington State need to know about what social media giants are collecting about us, or what actually any website is collecting about us. It just, we are so unknowing about what information is being taken, and technology giants, they're just every single day they're working on machine learning, they're working on data algorithms, and the courts, we've been working on this bill for the past 3 years. It's about time that we made some progress, and we need to get something passed so us as citizens, we have something to defend ourselves with. So that is my stance. I fully believe that we should be passing the Washington Privacy Act.
Okay. For me, I'm still unsure about the Washington Privacy Act. Just like looking at the origins of both, it's clear to me that there's like a little bit of collusion going on. In the case of the Washington Privacy Act, Microsoft had a lot of input in the formation of the bill with Senator Carlisle. While on the other hand, the People's Privacy Act was mainly created by the ACLU of Washington, and the Tech Equity Coalition, which is another civil liberties group. So I feel like, the major backing of both of these bills either lies within the industry or lies within, the people. So
I have a question for you.
yeah.
You keep mentioning the PPA and the WPA. Would you tell us what the difference is between the two, the main difference?
So both offer, data privacy and protections for citizens in Washington State. But the two main differences that kind of rise up is with the private right of action, and then either having opt-in or opt-out consent for the collection and use of your data. So in the case of the Washington Privacy Act, that's going to be opt-out, and there is no private right of action, as opposed to the People's Privacy Act, which is private right of action and opt-in.
Yeah, I think talking about, you mentioned Microsoft before. Do you think maybe Microsoft's influence is one of the reasons why the Washington Privacy Act doesn't have the private right of action?
I think it's definitely a contributing factor. I mean, if you look at other privacy laws, the one, particularly the GDPR, the General Data Protection Regulation from the EU, that has opt-in and a lot more heavy-handed action against companies, and it's clearly shown. There's several cases of Facebook and other tech companies really being handed very large fines by the EU under the GDPR. So I think the fact that the cases of where legal action can be taken against companies, that being limited in the WPA, I don't think it's a coincidence. I think it really does make sense. I mean, granted, Microsoft has also been very founded within kind of introducing privacy regulation. It's been I think since at least 2005, they bring up the topic of privacy legislation.
Mm-hmm.
To our viewers who are not quite sure about what the private right of action means, can Brenda or Daniel, can you elaborate more on what that is and why it's so important and relevant in today?
Right, so the private right of action is, it gives the ability for citizens to protect their own data. And so rather than leaving it up to the Attorney General to take on these large corporations, it gives the ability for citizens to file a civil suit in case their data is leaked or another instance like that.
So consumers are able to get a financial compensation, right, from these companies. Is that what I'm hearing?
Yes.
Oh, great.
I have a question again. I come back to Eric.
Yeah.
Just because I heard you talk about how Microsoft is heavy-handedly on the WPA one.
Yeah.
And I was wondering, do you think that they're able to give their input in this, or we're going to them because we currently do not have any laws apart from the California one to help, and yet they've been able to work with Europe because they also have their services in Europe, and so they've had to learn to be compliant with the European GDPR. And so do you think that could be the reason why we're leaning towards going to them for consultation and not just, and I'm not opposed to thinking that they probably are in it because at some point they're going to get some benefits out of it, or there are benefits that they might get into it. But I also would like to think that they're going there because they're the ones who've dealt with this. They know what to expect.
Yeah, I would say Microsoft isn't really the go-to for handling sensitive user data like Facebook or Amazon would, but at the same time Microsoft is also very invested in privacy once again. Going back to 2005, they released a statement, advocating not just legislation but comprehensive and federal level privacy legislation. Granted, back in 2005, but still that value still lies in the company. Another statement from 2018 kind of advocating for, stronger facial recognition regulation. So I think Microsoft is definitely out of all the major tech companies, an advocate more than the, more villainized ones like Facebook. So, yeah, I think, Microsoft is definitely a company that senators of Washington State have kind of come to, find as a useful asset in creating the Washington Privacy Act.
Yeah, to add on to that, I want to bring up that Amazon and Microsoft are supportive of the private right of action in the Virginia Privacy Consumer Act. So we do see examples where, even though they made that statement in 2005, they are still keeping that in the legislation part. So it's great seeing how these companies are doing this, but I also wonder, are they doing it because it's propaganda, or are they doing it maybe because it just sounds nice? Are there actual ethical concerns and like good heroes within that company? But with the private right of action, when they're supporting that, how effective really is it? And I do want to bring up a point where back in 2020, Facebook did settle for around $650 million, and this is with the Illinois Biometric Act. And the class members were expected to receive around $200 to $400 each. But the main thing is, with the public right of action, the attorney fees were awarded around $97.5 million. So with private right of action, even though the PPA has it and the CCPA has it, it seems like this really benefits the lawyers. And why is it relevant? Let's just pass the WPA, let's just get it over with, if all we're going to do is benefit lawyers.
And that's a good point. The reason that we want the private right of action is to benefit the citizens, and so it is disheartening seeing a lot of the money that it's meant for the people go to the lawyers, which, I mean, deserve compensation, but at the same time, we want the money to go where the money is for. And I think that's something that we need to keep our eye on when looking at the PPA, seeing how it goes about with the difference between what citizens get and what lawyers are receiving.
Yeah, I guess for me I think we're trying to pass something, and it has advantages, disadvantages, shortcomings, and pro it. And I'm thinking, yes, the money factor and the fact that it ends up being most of it or half of it going to the lawyers is a terrible thing. But let's not forget that this is not about the money. This is about it might be about the money for how the companies make the money, but we are mostly focusing on protecting the consumers and their privacies and their data. This is what I think is important. So, and sometimes I guess we have to worry: does the pros outweigh the cons? And just this doesn't have to be perfectly like this. It can always be. I think you mentioned earlier where the PPA would pay also for the government fees.
Yeah, it would. So there is a clause within it. Section 10, paragraph D, that says, in addition to any relief awarded to pursuit of subsection C, the court shall award reasonable attorney's fees and costs to any prevailing plaintiff. So if you win your private case against, a civil case against any company, your attorney's fees aren't entirely covered, but to a certain extent, it does eliminate, kind of this issue of lawyers generally benefiting from, any legal battle, because I think it's shown in the past where a lot of cases kind of do stretch on, especially in any corporate cases, and that's just mainly due to the fact that, the resources of an individual can't nearly, match up to a company.
That's true.
So it's been a valid legal strategy for companies in the past to just, outlast people in court and then force them to settle. But, in this case, it does allow, justice to prevail and not just, push it to the wayside.
Right, kind of going back to what Brenda was saying, where it's not necessarily about the money you're receiving from the suit, even though it's a great addition. It's mainly holding the companies accountable.
And I would just like to flip this maybe, and we mentioned earlier the difference being the opt-in, opt-out option.
Yeah.
And so I was thinking, we recently saw this with Apple and Facebook, and they went to war because Facebook was like, hey, no, Apple was like, hey, for this new update, you have to opt into advertising and them using your data for target advertising. And Facebook was like, they were like, no, if you make us do this, if we can't use your data. And I feel like it was like a manipulative tactic, because like, if we can't use your data, then we'll have to charge you, and your businesses will have to charge you to use Facebook because we make money off of advertisers. And you wouldn't be able to talk to your family members or your friends, and then we will also have to charge small business owners. And we saw when Facebook went down for that one day, we saw how it really impacted small business owners because they all also depend on Facebook. So it's like there's a good thing that comes out of it, but most of it is also really evil, and it needs to be governed. And I think that's where the ethics come in. It's how far are we willing to go, or what are we willing to get out of this law? And so with the opt-in, opt-out, I think is also, I think this is a question, and I'm going to direct it to you.
You being Matthew, right?
Yes. Matthew, sorry. My question would be, do you think the Apple's strategy of opt-in would actually make consumers worry about, or make them concerned about how their data is being used? Because is it difficult? Do you think they'll go in and be like, hey, I don't want to opt in, or will it make them caution? Will it give them caution about it, or how their data is being used? What do you think?
Right. So you brought up several topics, and I do want to address a few of them. The great thing is that first, Facebook doesn't actually sell data. This is a major misconception. What they sell is the access to data, access to users based off of data. So their entire business model is selling to the advertisements, and they're able to search up metadata that we're able to just be collected. And then so that's why Facebook is so into the opt-out policy rather than the opt-in. And I do think that there is a huge difference. There's a huge difference on what this will do for society, on this will do for people's recognition of data privacy. With opt-out, yes, anyone can opt out. But do people actually opt out? And when they do, how hard is it to get there? It's simply just propaganda. And that's something that people need to realize, that opt-in, I think, is a lot better. And I will say this, even though I do support the WPA, the PPA does have a great point when it says to opt in. But opting in also has its caveats. You can't just say that, oh, because you're opting in, you're going to think about its product. Most people just ignore it. Back when the European countries, when they passed regulation, all that happened was just a ton of memes on Reddit about updating your privacy policy. Granted, that is great for us, knowing that people are more aware of privacy policies being updated, but who actually takes their time looking at privacy policies? We've done this as a class. We know that it's just no one seems to care unless we're doing it as a class assignment. So, yes, I do agree. Opt-in is better. Do I think it's going to change a lot? No, but is it better than opting out? Yes.
Yeah, I think one of the major things with opt-in versus opt-out is kind of the subtle changes that it'll end up making. Because you're right, most of the time people won't even notice the difference between opt-in and opt-out, and they'll just click the button that pops up on their screen. But I think it may cause people to more, or to think about how their data is being used, maybe not in the forefront of their mind, but maybe more in the back. And I think that's an important thing to kind of start getting people to think about with how all these major corporations are using our data.
And I think the recent happenings on TV about Facebook using data and this whistleblowers coming out is creating some sort of awareness that, hey, when you're there just commenting on your post, something else is going on the other side. And hopefully that gets people to look at it. But all we can do is sensitize people on these issues and then lobby that our lawmakers look at these policies and create policies that will protect both the people and their data.
Mm-hmm.
Yeah.
Yeah, I mean, looking at it more now, I think PPA or WPA, whatever happens, I think it's more of the statement of people are now, aware of, the impact of their data. They're more aware of their digital footprint. Because I feel like, before, obviously all this, Facebook Senate hearings, I feel like no one really cared. The internet was kind of just out there and, just kind of nether space that, people don't really treat as real. But, in the end, as long as people realize that, what we're doing online, what and how, larger corporations are, using that information, I feel like at the end of the day, WPA, I think does stand a little bit of a better chance to pass. The PPA is a bit aggressive, I will have to say, towards the companies. It's very much towards, servicing the people with, like, as Brenda brought up, like, with the reason why Facebook is free is because of how they utilize data. But, in the PPA, it does kind of cover, companies can't upcharge or refuse to serve customers who don't allow access. But as a result, once again, that does have a lot of repercussions on kind of the system. And once again, as Matthew brought up, at the end of the day, people kind of just care if the trains run on time. They just care, can I scroll through my feed? Can I talk to my friends and family? But I think if we can get consumers to consume more mindfully, I think that's what we're looking for at the end of the day.
So am I potentially detecting a change of statement, Eric, from your original statement?
Yeah. As long as, end of the day, once again, WPA looking like the stronger option.
So you just want something passed, and whatever passes works, right? Okay. No?
Well, I think with room to growth.
Okay.
Of
course.
absolutely.
Of course.
Yeah,
I
because
think
it's like,
for the law.
once again, I feel like a lot of issues do stem from a lot of times, especially in American law, no less.
Yeah.
There's a lot of laws that are passed, and, that becomes the standard for however many years. And it takes an immense amount of work, because American law is just so layered upon, previous, cases or laws being passed that we do need to have room for growth.
And not to mention laws get outdated. I mean, we could talk about Section 230 or any other various forms, but maybe on a future episode.
Yes.
But yeah, I think something just needs to pass, and WPA is looking a little stronger.
I agree with your statement, Eric. Anyone else?
Yeah, piggybacking off of that, I would definitely say I love the PPA, and I love a lot of the things that it talks about and wants to put in over the WPA. But at the end of the day, the point of a Privacy Act is to protect the people's privacy and to protect their data. And if the way to do that is to get the WPA in now and then make amendments in the future, I'm all for it. And I'm all for protecting the people's data as soon as possible.
Let's do it.
Okay, it seems like a good majority of us, and I believe all of us actually, have reached a consensus. that's it for this episode of Dabbling with Data. We're really excited for next week when we talk about open sourcing and with Microsoft. But I want to just say thank you to our guests, and we'll see you next week.
Bye.
Bye.
Bye.